You're listening to Systemic Error Podcast. The failure was designed.
Trump's Supreme Court election bid may not be what it seems, based on an article by Sarah K. Burris. The Postal Service is a ballot choke point. What this case is really about, this is not a story about legal nuance in the abstract. It is a story about a president trying to use the machinery of the federal government to choke off ballot access in states he does not control. Trump's Justice Department filed the case. Trump's executive order is the instrument. The Postal Service is the lever. The target is mail voting in blue states and Washington, D.C. That is the power structure. Everything else is commentary. The real decision was made in the White House. The key fact is not that the Supreme Court may hear something. The key fact is that Trump issued an order aimed at taking federal control over how ballots move through the mail. According to the source material, Judge Indira Talwani already ruled that Congress has not given the Postal Service the power to control mail-in voting, sort mail for partisan purposes, or refuse to deliver ballots to some voters. She called the order legally void. That matters because this is not a debate about election administration in the ordinary sense. It is an attempt to turn a federal service into a partisan filter. Trump made the decision. His administration is defending it. The states are reacting to the injury after the fact, which is exactly how executive overreach works. Act first, dare the system to catch up later. The reporting tries to make this smaller than it is. Steve Ladek's point, as quoted in the source, is that much of the coverage is inflating the procedural posture while missing the substance. The immediate Supreme Court fight is about timing, standing, and rightness, not a full merits ruling on whether Trump can legally weaponize the Postal Service. That distinction is real, but it is also a trap if it becomes the whole story. Procedural fights are how institutions delay responsibility while a political project keeps moving. A court can spend weeks or months arguing over who can sue, when they can sue, and whether the case is ready, while the executive branch keeps trying to make the underlying abuse a practical reality. The misdirection is built into the legal process. The danger is not lessened because the most explosive question gets postponed. The mail slot is the crime scene. The source makes clear what the order is reaching for: the ability to refuse or obstruct delivery of ballots by US's action, especially in blue states. That is not routine postal management. That is election interference dressed up as administration. The order's defenders are not even making a broad case that Congress authorized this power. They are fighting over narrow timeline issues and emergency relief. That tells you enough. When the strongest argument available is procedural delay, the underlying policy is already indefensible on the merits. And let's be blunt about the institution involved. The Postal Service is supposed to move mail, not sort voters into categories of deservedness. Once the executive branch claims that power, the line between logistics and suppression disappears. The states are chasing the harm after it has already been initiated. 5 lawsuits have already been filed. 23 states and D.C. are in the Supreme Court case. That is not a sign that the system is calmly deliberating a novel question. It is evidence that the administration's move was broad enough to force immediate resistance from multiple states at once. The source also notes that even a Supreme Court hearing would likely only delay the core reckoning by weeks. That is the nature of executive sabotage. Create enough procedural friction that the clock itself becomes a weapon. If the case is still moving while ballots are moving, the harm is already underway. This is why coverage that centers on whether the ruling was divided is beside the point. The meaningful divide is between a political actor using federal power to interfere with voting and a legal system trying to decide how fast it can say no. The pattern is open authoritarian method, not confusion. The larger pattern is simple. Trump does not need to prove the election was stolen if he can make the machinery of voting harder to use, harder to trust, and easier to manipulate. He is not waiting for a crisis. He is manufacturing one through the state itself. That is why the story should not be framed as an arcane battle over emergency procedure. It is a test of whether a president can repurpose federal institutions into partisan choke points and then hide behind litigation while the calendar does the work. The constitutional issue is real, but the political meaning is larger. This is administrative coercion aimed at the vote. The lesson is not that the courts are confused. It is that the executive is willing to use confusion as a tactic. You've been listening to Systemic Error. Thanks to Alternet for today's article. With the automated voice of Kiesel, thanks for listening.